Conversation with Marshall Chriswell is presented by WCCS, AM 1160, 101.1 FM, and this program intended for informational purposes only. The information does not constitute legal advice. The law is constantly changing. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Good morning.
Good morning.
It's good to have you with us this morning.
Nice to be here.
All right. So one of the more emotional things I would assume that you ever deal with is when it comes time for custody of children in a divorce settlement. Would that be true?
Absolutely. More emotional, obviously than the financial aspect of the divorce, who gets the house and how we divide retirement accounts and all of those things. That can be emotional because of the context, but child custody absolutely is probably the most emotional thing that I deal with.
With that in mind, there is a bill currently before the State House of Representatives, and it has to do with that custody battle between husbands and wives who are now divorcing. And well, I'll let you explain it because it's pretty straightforward right down the middle, isn't it?
Well, it is. It's HB 1397, which was introduced in the Pennsylvania House of Representatives last spring. And it's one that's being watched closely by family law practitioners like myself. It's gained some traction. There have been hearings held in the late fall, so it's still in the Judiciary Committee at this point. This is a law that will really fundamentally change the way that child custody cases are handled, are litigated, are decided. What it says is that in every custody case, it creates a legal presumption that the parents should have equal parenting time. Mm-hmm. And it defines equal parenting time as close to 50-50 as is possible, mm-hmm. But not no more disparity than 60-40 percent.
Yeah.
Okay, of parenting time. Generally, we count parenting time by the number of overnights that a child spends at a parent's house. So yeah, this is a law that has been it's kind of started out, I think, being championed by groups that sort of call themselves fathers' rights groups. There's an impression, I think, among these groups that dads don't get a fair shake in custody cases, and hey, what if it should almost always be equal time between the parents. Mm-hmm. So it's a really interesting concept. It's one that was raised actually when the child custody law was amended back in 2011, and it wasn't included in the law at that time. Mm-hmm. But here it is again.
All right. So that being the case, and whether you feel that that's the right direction or the wrong direction, there certainly are consequences that have to be considered, and certain considerations such as distance from one parent to the other. If a parent moves to another portion of the state or another region, another school district, all of these things have to come into play, don't they?
That's right. And what we have now, the way that child custody cases are decided in Pennsylvania, is there is a list in the custody statute that it sets forth 16 factors. Okay, and these range from as you said, the location, the proximate distance between the parents' residences. It also covers things like drug and alcohol abuse, domestic violence. Things like which parent is more likely to promote a positive relationship with the other parent. There are all sorts of factors. So judges right now, judges analyze each one of these 16 factors, and basically the way that judges look at these cases, and I've heard them, they've said as much in court, for the most part, is you always start from the position that, okay, why shouldn't this be a shared custody case?
Okay.
And then you go through these 16 factors and you say, okay, which ones, weigh in favor of mom or dad? And then you're able to make a decision about, okay, should it really be a shared custody case? Or, do these factors weigh heavily in favor of one parent or another? And how do we work a schedule based on that? Mm-hmm. So that's the way it's currently done. And I think that I think it works well because although it's complicated, it takes into account that every child is different, every family is different, and every situation has very nuanced facts which need to be examined closely.
Mm-hmm.
This bill, while I think it's got good intentions, would create a cookie-cutter approach.
Yeah.
Every case is going to be, okay, it's going to be 50-50 or 60-40 without taking into account what might be in the child's best interest.
Mm-hmm. So you have a platform now from which you have to operate, and that platform is 50-50. You have to stand in the middle as a judge, and that's the goal that you are seeking, except for mitigating factors.
The current system that we have now,
yeah,
right.
Well, and much more rigid than under this legislation.
1,000% more rigid. What it does, and so the legal term is clear and convincing evidence. This says we have a presumption. In every case, a judge has to give shared parenting time unless there is clear and convincing evidence that it should be something else. What is clear and convincing evidence? Well, we don't know until the appellate courts start to interpret that language, should this bill be passed. But, there are lots of situations that I think warrant more parenting time for one child, one parent or another, that maybe wouldn't rise to the level of clear and convincing evidence. Domestic violence situations. You have a parent that was abusive to the other parent during the relationship, wasn't abusive towards the child, was just abusive towards the other, and the child may have witnessed some of this.
Sure.
Would that in that situation, would an appellate court determine that rises to the level of clear and convincing evidence that you shouldn't have 50-50 time with your child?
Yeah.
There are all sorts of things, substance abuse and parental alienation issues and all kinds of things that play into it. But I think the bottom line is it would create a cookie cutter approach that, man, I don't know. It just doesn't seem to me that in a lot of cases it would meet the best interests of the children.
Before it ever got to the appellate area, perhaps the legislature, because it takes so long for something to become a law, once the objections and the modifications, the amendments are added to it, it seems as if they would have to really codify some of the behaviors that would mitigate against having the 50-50 split. They would have to actually put it in code before it actually became law. And then once it became law, the courts would still have to get a hold of it. The appellate courts would have to, okay, this is what the legislature meant by this. This is how we define this in relation to what the legislature said. Mm-hmm. It seems like a real difficult, complicated scheme that they would have to come up with.
Yeah, and it would be interesting to see what the amendments that that would be presented on the House floor and how that would play out. As the bill is written now, it merely says you've got a presumption of equal time that can only be rebutted by clear and convincing evidence otherwise, and it's up to the courts to decide what that is. And right, there may be some clarification given to that through the amendment process, but it's just a really interesting piece of legislation that at this point it's been opposed by, I think, the Pennsylvania Bar Association and the Pennsylvania Psychologists Association in recognition that, again, every child is different, and meeting shared custody, while it may be sometimes the goal of the parents, right? Many parents in child custody cases say, hey, my goal is to have shared time. My goal is to see my child 50% of the time. And I don't think there's anything wrong with that, but you're looking at it from the wrong perspective. You're looking at it from an egocentric perspective. You're saying, I want shared 50-50 custody, and you're not looking at it from the perspective of the child who who it may not be in their best interest.
It'd be interesting, since Representative Struzzi has just been named to the Children and Youth Services Committee in India in the state legislature, in the state house, how he would weigh in on that topic as well. And I'm sure that before this ever went through whatever committees it has to go through in order to make it to the House floor, that his committee would have to take a look at it. One would think.
You'd think that they would that they would definitely want to weigh in on that. Yeah.
As it is now, when you are meeting with a client who is involved in a divorce case, and those discussions come up, it has to be very, very delicate. And you, as an attorney, of course, you have to make certain judgments as well as to what would be the proper split of time between parents. And there are so many different factors. I would guess that would be a very difficult aspect of what you do.
It is, and you're right, with all the different factors and with every case. I think that's something that's difficult for people to understand in a lot of situations. They talk to friends or coworkers or about, okay, well, how did your case turn out, and what happened whenever you and your husband split? Mm-hmm. And you can't base a future outcome on somebody else's case. Every case is so different, and it really takes a lot of advocacy on the part of the attorney, and knowing how to present that case to a judge to accentuate, what the parts of the argument and the different factors that you want to be taken into account and given weight in the judge's analysis. So it really is definitely a complicated, but a really interesting area of the law.
Yeah. Wow. I bet you there's a whole bunch of layers to that. Somebody comes in and they want this amount of custody. And you can look and you can, based upon your experience with what some of the factors are, you can say, well, in similar cases, the judge would never have gone for that. And right. Therefore, maybe you need to lower your expectations, or maybe you can raise your expectations based upon what the other side is saying. A lot of judgment that has to be involved in the way that you counsel your clients.
Really, and that is why, in these cases, it's really important to meet with an attorney and to get at least a consultation, because we do know. I mean, we've seen so many of these cases, and it really can give you an idea of where the judge would be heading, what the potential outcomes are, and there's always a range of outcomes mm-hmm. depending on what happens, but yeah, it's so important, to get in touch with an attorney, to sit down and at least have a consultation, so that going into it, what your expectations are.
Yeah, we'll be following this case with great interest. All right, somebody needs to get in touch with you about this or any other legal matter. What do they need to do?
You can give me a call at 724-465-5826. Stop and see me in the Atrium Building, downtown Indiana, or go online to westernpalawyer.com.
Thank you.
Thank you.